on 30/3/2025. I further submit that the TGPSC issued a press note on 13/3/2025, providing greater clarity and confidence regarding the evaluation process. Press note stated as, but I skip the press note, then paragraph 16 at page 8. It is further submitted that the averments made by the petitioners that the respondent commission has no role to scrutinize the marks awarded by the evaluators is imaginary, speculative in nature, without any proof, and is a misinterpretation. Without any proof and substantial records, petitioners are raising baseless allegations in the commission, which is a constitutional body. It is herewith submitted that respondent commission has the authority to conduct recounting of papers as stated in its rules and procedure. That recounting is at the instance of a candidates making an application. Otherwise, they have no role. If I were to bring to your lordship notice to the paragraph at page 111, they themselves disclose that the commission has scrutinized at Roman 7 at page 112. Last three lines at page 112. As a measure of abundant caution, the marks awarded were once again scrutinized by the commission without knowing the identity of the individuals. That we have stated, once an evaluation is done, the question of scrutinizing by the commission does not arise. Now again, going back to the counter minute, paragraph 14.
Yes.
14 minutes, 17 minutes. 17, I may skip minute, paragraph 18 at page 9. That it is submitted that it is incorrect to state that evaluation procedure adopted by the commission is faulty. Commission has conducted the group 1 examination, so they reiterate. Then paragraph 25 at page 12. Page 12, paragraph 25. That is to submit that the commission has always adhered to the standard procedures and guidelines in evaluating answer scripts. Myriad of subjectivities and probabilities cannot be dragged into horizon of rational interference or an allegation as presented by the respondent based on it, which is wrong to state that there is an endemic selection and thereby is an irregularity and inconsistency. It is quite pertinent to note that an allegation of irregularity cannot stand merely because the subsequent candidates attained similar marks. That is how the comparison of same mark getting. Then paragraph 26 at page 15. Page 15, paragraph 26. It is to submit that the respondents' contentions regarding the press note and their misinterpretation of evaluation of papers and appointment of unqualified examiners for evaluation are totally hypothetical, vague and baseless. Commission with utmost care and diligence has conducted the group 1 examination, conventional descriptive type, and utmost care has been taken in evaluating answer scripts of the candidates, except in their respective experts in their respective subjects having domain knowledge were engaged in the evaluation process, and the marks awarded by the examiners were thoroughly verified. No information can be revealed or was revealed as to who evaluated the papers, but the respondents exactly so and so. But I may not trouble your lordship. But that is the counter. First counter, they do not refer to the third evaluation which they allege to have undertaken. Then the second counter they have filed, that is at page 21. paragraph paragraph 47 at page 53 minute. Page 53, paragraph 48. Heading is Allegations regarding evaluation method and evaluators. The petitioners have leveled speculative allegations that evaluation process was hasty and deficient and evaluators were overburdened. Petitioners have also alleged that same evaluators evaluated both English so and so. I may skip over. Paragraph 49. All answer scripts in main examination are evaluated by two different evaluators. However, in case there is a difference of more than 15% marks awarded between two evaluations, a third evaluation is carried out. The process of evaluation of each evaluator is closely monitored by Chief Examiner to ensure that the scheme of evaluation is strictly implemented in terms of the uniformity and fairness. For this purpose, Chief Examiner independently evaluates 3 of the answer scripts already evaluated by each evaluator from each answer booklet bundle on random basis and gives guidance to the concerned evaluator in terms of the implementation of the scheme of evaluation. For the first time, this was brought to the notice referring to the para. I will refer to para 62, then I make my submissions. At page 58. Page 58, para 62 minute. Para 62 minute, I will read minute. Since all the papers are evaluated twice, as stated above, provisions have been made on the first page itself for 2 evaluations. However, the third evaluation, which is necessary only in a few cases, is provided for on the third page of the answer booklet. Sample answer booklets are published on 16/8/2024 and annexed to this affidavit as Annexure R3, which contain the pages for all 3 evaluations. But then paragraph 64, last 3 sentences at page 58. The third evaluation form can still be identified with the same barcode given in the answer script. But I will read para 64 minute. However, the answer book was stitched part running on one side and is untearable and undetachable. This stitched part of answer script has the barcode running along the answer scripts. This part of answer script contained barcode remains undetached even after the OMRs for the first and second evaluation are detected. Owing to the barcode on the stitched portion of the answer script, third evaluation form can still be identified with the same barcode given in the answer script. The third evaluation form also has the provision for signatures of evaluator, chief examiner, and scrutinizer. OMR evaluation form is scanned after each evaluation in the interest of integrity of evaluation process. Since the third evaluation form has signatures of the evaluator, chief examiner, and scrutinizer, there is absolutely no scope for any manipulation. They try to support this on the ground that OMR evaluation is not available in the third, even as per their model answer booklet, which they have communicated in August 2024. If the OMR evaluation form is not available, then it has must be done in the manual form. Whereas in the notification, it was clearly specified that OMR is done only for the purpose of awarding of the marks at para 11.2 of the notification. Thus, the deviation from the first and second and third, no material document is filed along with the counter affidavits. An assertion without any basis and which is not continued in the earlier affidavits filed by them. And this affidavit is filed, Your Lordship may see, at the fag end of the arguments on 24th June 2025.
Yes.
Then I will refer to the paragraph 70 at page 61. The petitioners in WP 11439 of 2025 further allege that no moderation scaling of the marks was carried out in the present examination. It is submitted that moderation or scaling is a method that enables the rationalization of the grand totals in favor of few discipline subjects and is dependent on the pattern and the scheme of that examination. It is adopted in examinations at the discretion of the recruiting bodies, which involve multiple optional subjects. However, no such moderation is required in the Group 1 examination because all papers are mandatory and all candidates take the very same exams.
Yes.
Therefore, they categorically, an averment is made that no moderation is required for Group 1 examination because all papers are mandatory and all candidates take very same exams. Then, one more additional affidavit is filed at page 66 of the very same paper book. This is filed on 8/7/2025. You also may note 8/7/2025 arguments were concluded, judgment was reserved. Written submissions were only required to be filed. At page 66, the respondent commission, paragraph 2, respondent commission is filing the present affidavit in furtherance of the averments made in the common additional counter affidavit dated 25/6/2025 at paragraph 48 to 54. As stated in paragraph 52 of the said counter affidavit, evaluation process starts with conduct of chief examiner committee meetings to finalize answer keys for all papers, including scheme for award of marks. Then they say paper specific answer keys are prepared and finalized by the committee of chief examiners with support and involvement of the concerned subject experts for every paper along with the scheme of award of marks. This entire exercise was undertaken before the commencement of the actual evaluation of the answer scripts. This exercise is conducted in relation to paragraph 4. English and Telugu languages. In relation to Urdu, a translated copy was prepared using English answer key as a reference, as there are limited candidates opting for Urdu medium. 5. Answer keys along with the scheme for award of marks for all 7 papers are being produced before this court in a sealed cover in view of their extreme confidentiality. Then paragraph 6. All evaluators engaged in the assignment of the answer scripts were provided with relevant answer keys and the scheme of award of marks. Then paragraph 10 would be relevant at page 69. A perusal of answer keys and system of supervision highlighted above would indicate that evaluation was uniform across all mediums without any deviation. Next sentence is very crucial. The consistency in evaluation is also evident from the fact that 5,558 answer scripts out of the total of 1,47,770 necessitated a third evaluation. Passing here, 5,500 answer scripts. If taken as an individuals, all the individuals are required to answer 7 papers. Otherwise, their answer books will not be evaluated. If this 5,558 is divided by 7, it would be 763. So they have third evaluation is undertaken for more than 700 candidates. And no details are made available either in the web note or in the any documentary evidence to show in what manner they have undertaken that exercise.
Yes.
5,558 by 7 would be more than 760 minutes. Therefore, the third evaluation made a magic figure. They say it's only 3.76. But if they are taken, total posts available are 563 only. For 563 posts, the candidates to be identified are only 563. But they have done the third evaluation for more than 700 candidates. No basis, no documentary evidence is filed. And then what they say is, what is the moderation which they have followed is not also clarified. Then again, these 3 conjoint readings would show at every stage, chief examiner has conducted a mock examination, mock verification of the answer scripts before the actual physical evaluation of the answer script started, is the submission made in the affidavit. If that is so, there is no rationale why they have undertaken the second evaluation. There is no rationale why they have undertaken the third evaluation. And no decisions of the commission with regard to the second evaluation or third evaluation are brought in the form of any documentary evidence before this honorable court. The 3 additional affidavits which I have filed would disclose that there is no consistency in the stand of the Public Service Commission in conduct of examinations. That itself is a arbitrary writ at large violating Article 14 and 16 of the Constitution of India would be my respectful submission. But how this has been dealt with by learned single judge is available. Paragraph 341 at page 301 of volume 3. Volume 2, Milad, I stand corrected.
Paragraph
341 at page 301. Last sentence only, procedure of evaluation. Let me go over to the next paragraph at page 342. The TGPSC issued a press note on 13/3/2025 providing greater clarity and confidence regarding the evaluation process. Press note so and so minute. Then I may skip over the paragraph 343 also. 344. As per the above note, double evaluation for all answer scripts is mandatory. Hence, the evaluation was overburdened. Same evaluators evaluated both the Telugu and English answer scripts, which caused prejudice to the candidates. Commission denied all the allegations as baseless and untrue. Initially, answer scripts was evaluated by two different evaluators. However, in case where the case of difference in marks awarded by two evaluators exceed 15%, a third evaluation is carried out. Chief examiner closely monitor the evaluation process to ensure that scheme of evaluation is strictly implemented in terms of uniformity and fairness. Learned judge does not give any justification to refer to that, be that as it may, paragraph 345. While arguing the matter, this court asked the commission if there is any procedure for evaluation of all answer scripts and any key to that extent. Surprisingly, initially commission stated that there is no key. The commission replied that all evaluators are subject experts and that it is not the multiple choice question paper to prepare a key, but rather descriptive type answers. Again, the court exclusively asked the question, for example, in paper 6 of the Telangana movement, one candidate will write with full information within 1 page, some other candidates will write the same in 10 pages. Under those circumstances, how will the evaluators give the marks? For this question, there is no answer and repeated as stated supra. The commission answers reflects that there is no proper method to evaluate the answer scripts. Subsequently, the commission engaged senior counsel, and even then also, there is still no proper answer to the court's satisfaction. Again, the court asked regarding to the key, any method of awarding marks in different answers. For that, learned senior counsel stated that there is no such key, as the court said, but commission prepared key to all the question papers, and then the court asked them to produce the same in a sealed cover. Accordingly, commission finally produced all the certified copies of the key answers in the sealed cover in the open court. It is pertinent to mention here that the commission changed its voice time to time, and it is observed in their own affidavits on 3 occasions. Firstly, commission submitted instructions before the court. In the said instructions, nothing is mentioned in it, but in oral submissions replying to this court as stated supra. Secondly, after granting interim direction, filed vacate petition. In the said vacate petition, the commission stated that examiners valued the scripts well versed in Telugu, evaluated Telugu medium answer scripts, and adequate subject experts who were engaged to evaluate in Telugu, English, and Urdu mediums. In addition, commission did not provide any information regarding on the method of evaluation or preparation of the key. Finally, the commission filed a common additional counter affidavit. In the said affidavit, the commission stated as follows. Evaluation process starts with the conduct of so and so. I will not trouble you, Lordship. Last three sentences of para 345. In these three affidavits, there is inconsistency in their own statements regarding the evaluation procedure. So all these acts of the commission reflect that there is no proper evaluation, transparency and fairness. Then para 346 minute. While explaining the evaluation method, learned counsel appearing for the commission said that on 3/7/2025, there are three methods of evaluation in our country: scaling, normalization and moderation. Commission has stated that scaling and normalization is not applicable in this examination. The commission fully followed the moderation method in evaluating the answer scripts. On 25/6/2025, the commission filed an additional common counter affidavit. In the said additional counter affidavit, commission explained which type of evaluation followed in para 70 as follows. Petitioners in WP further alleged that no moderation scaling of the marks was carried out in the present examination. It is submitted that moderation or scaling is a method that enables rationalization of grant totals in favor of few disciplined subjects and is dependent on the pattern and scheme of that examination. It is adopted in examinations at the discretion of the recruiting bodies, which involve multiple optional subjects. However, no such moderation is required in Group 1 examination because all papers are mandatory and all candidates take the very same exam. So even moderation, which they say that we have not undertaken because it is not required. So there is no scaling, no moderation, no normalization in the main examinations. That is how the learned judge referred to at paragraph 347. Shockingly, the commission has given contradictory statements and court understood that commission did not follow any proper method and instead relied solely on its own selected expertise evaluators. The entire evaluation process undermined the sanctity of the Group 1 examination. Then, paragraph 354 at page 309.
We'll go through that.
Yes, my friend has referred to, I will not refer to it. Then, paragraph at 311, only 8 I will refer to. With regard to the key, there is no proper explanation in relation to answers. Some of the keys showing only subheadings and there is no description, and some of the keys there is an elaborate description. Some keys are showing two types of grading figures. Then para 356. Based on the above observation of the sealed cover information, this court believes that the commission did not follow a uniform method to evaluate answer scripts. There is no discussion in the entire commission's arguments regard to the evaluation of the answer scripts and the answer awarding of grades. While fixing the grade, there is a note if any candidate awarded excellent or outstanding marks, evaluators have to consult the chief examiner. Even this also nowhere discussed in the entire arguments by the commission. And there is no mention regarding grading in commission's counter. This is very shocking. Then I may not trouble you lordship with that. Then the operative portion, my friend has referred to it. Therefore, it's a very clear case where there is no clarity on behalf of the Public Service Commission in making affidavits before this honorable court, and no documentary evidence is produced how that second two evaluations is mandatory. When such a decision is taken, no averment in the affidavit pleadings, counter affidavit pleadings. But keeping that in view, I may request you lordship to go over to my citations which I have filed. in support of my contentions.
You can refer to the citations and the paragraph numbers.
Yes, ma'am. Yes, ma'am.
We'll take note of it.
But in my written submissions at paragraph 10, page 6, paragraph 10, 11, 12, I refer to. Paragraph 10, page 6 of my written submissions, I refer to the judgment of the Supreme Court in State of Tamil Nadu versus G. Hemalata, where the Honorable Supreme Court held that any instructions of the Public Service Commission and the notification are mandatory, and they have to be adhered to and followed. But the paragraphs, I'll ask one of my colleague to pass it on to you all, with regard to the serial number 11. And in respect of judgment in 1999 3 SEC, I refer to paragraph 31 and 32. And 2005 1 SEC, paragraph 26, where it specifically stated that once the notification is issued, the Commission is mandated to follow the set prescribed procedure. And if they wanted to deviate, as I was referring to paragraph 18 of the notification, they can do so by giving the details to the public, to the everybody who are concerned. Admittedly, in any of the notifications, there is no prior communication at the time of evaluation to say that we conduct the evaluation mandatorily for more than one evaluator. And then one of the issue which they have raised is that after participating in the process, I have raised these objections and approached this Honorable Court. In this regard, my respectful submission is this process which has been notified has not been adhered to, which we came to know only after we participate in the selection process. Because we have no grievance with regard to the conditions specified in the notification. Only grievance which we have is notification has not been meticulously followed by the Public Service Commission and Rule 3 of the regulations of the Public Service Commission. And may I now go to the one aspect of it, then I may conclude. Notification by the Public Service Commission refers to the rules of procedure to be followed by the Public Service Commission, Rule 3(9)(d). Those rules are filed by the Public Service Commission in their written submissions at page 244. May I seek the indulgence to refer to that written submissions of the Public Service Commission.
Yes.
The written submissions filed by the Public Service Commission. At page 244 it starts, Telangana State Public Service Commission Rules of Procedure. Rule 3 of the rules at page 245.
Yes.
Where any competitive examination is to be conducted by the Commission for the purpose of direct recruitment to a state or subordinate service, Commission shall announce. Announcement, I may not trouble your lordship. One is the announcement, two is the written examination, online examination or a practical test, whatever may be. Then note at page 247, note 2, subnote 9. The commission shall arrange the candidate selected by it in the order of merit. Page 247.
Yes.
Arrange the candidate selected by it in the order of merit. Announce the results on the notice board and website of the commission. Forward the list of so and so. Then D also, D, revaluation of the answer script shall not be entertained under any circumstances. However, recounting of marks will be considered within 15 days from the date of publication of result. But revaluation of the answer script shall not be entertained under any circumstances would be applicable both to the Public Service Commission also, unless they have specified in the notification or in the communications at a later stage that they will undertake the valuation of the answer script by more than one valuer. But revaluation or a double valuation is one and the same according to my submissions, because if you do it more than one time, it is a revaluation. If you do it only twice, it is a double revaluation. Then Roman 10 also makes a difference. Notwithstanding anything contained in these rules, the commission may, in consultation with the government, adopt for the purpose of recruitment in any particular cases or class of cases a special procedure, as is more appropriate than the one prescribed in any of these rules. They have a power. That power has to be exercised strictly in terms of the notification, which says we will update you as and when we make any modifications or changes. Such an updation did not communicate that the evaluation will be by more than one evaluator. Therefore, the note where the rule 3 note would clearly show that reevaluation is not to be entertained. Therefore, once the Public Service Commission takes such a decision, it should be in consultation with the government, and there should be a document which should have been averred to in the counter affidavit filed before this honorable court.
Very well.
Therefore, my respectful submission is last submission. In view of the tearing of the OMR sheets, now the question of again conducting a evaluation as observed by the learned single judge may not be sustainable. Therefore, the only method available is to conduct an examination by duly notifying the procedure which they intend to adopt for the purpose of recruitment to the Group 1 services.
Yes.
That was the reason I made my cross objections, my writ appeal is to that extent. That is the writ appeal 1470 of 2025. 1470.
That's all.
Yeah. May I refer to one item number, item 17, Writ Appeal 589 of 2025. Although it is filed by unsuccessful candidates, the writ petition is dismissed at the admission stage. May for a moment take up that item 17.
This compilation of judgments, which judgment do you expect us to go through? Hemlata, you pointed out.
Then, the two other judgments are also that once a procedure is contemplated, it has to be adhered to.
Babu Varghese.
Yes, Babu Varghese.
Very good.
Very good. Babu Varghese and State of Jharkhand versus Ambe Cements, 2005 1 SEC.
Yes.
May I refer to this item 17? I may take less than 5 minutes. But am I audible? I am unable to get the. I am.
very well thought of, well considered, and well balanced. And Millard's, my task before your lordships could be to persuade that the judgment needs no interference because it has taken care of every aspect that's been raised. And that's why, Millard's, essentially I've confined my submissions to the points that have been urged, raised, and addressed by the learned single judge. And Millard's, in each issue as has been dealt with by the learned single judge, I have kept them separate, and also I've given the paragraph numbers of the rival arguments and essentially the finding of that one. Millards, my humble prayer to your lordships is that, Millards, if I try to labor on a point which has already been clear, my lords may kindly shut me down and say that I should move on, because, Millards, I was not privy to the earlier arguments. That's why I suffer from that ignorance. Otherwise, Millards, I would like to be very short and, if possible, effective.
Mr. Vidyasagar, that particular writ appeal on the badge, after the batch is.
Oblige.
Millards, last 1 week, we on both sides must have traded in words, so many of them. It reminds me, Millards, the Hamlet's classic reply to Polonius when he asks, "What are you reading?" Hamlet says, "Words, words, words." Immediately, Polonius jumps to, or wants to jump to, a conclusion that Hamlet, the prince, was mad. But he realizes there should be some method to the madness. At the end of the Millards, with all the words, my lords would be finding out whether there's any method on either side. And Millards, now, when it comes to the appellants, Millards, they would have the constant refrain, as I could be on that side, that judicial review has a very limited scope and the learned single judge has exceeded the mark. And second one could have been, Millards, the failed candidates always try to blame and pass the buck. Otherwise, there's nothing much meritorious. That could be the second one. Millards, then they say that when it comes to the recruitment agency, there should be free play at the joints, and they could not say that there is a comma missing, there is a full stop missing, then it becomes impossible for the recruiting agency. And Millards, they've also, it seems, laid much emphasis on the fact that what is the prejudice that's been caused to you? And if at all there is prejudice, the burden is squarely on you to establish that this is the prejudicial element, lest you should not be heard. This could have been the fulcrum of the arguments in my humble submission, Millards. Left to ourselves, as the respondents and initially as the petitioners before the learned single judge, Millards, we say, Millards, state or its instrumentality, their actions cannot be arbitrary. Once they are arbitrary, Millards, it amounts to antithesis to the rule of law. Then, Millards, once either Article 14 or 16 or both of them come into play, the question of estoppel or waiver does not arise. Then, Millards, when it comes to this prejudice theory, Millards, when the statute, rule, or regulation, even guideline having the force of law, when they are silent and to supply the crevices, to fill in the blanks, then this question of natural justice and equity principle and essentially the violation leading to prejudice would come. Once there is a constitutional principle at play, Millards, I cannot even waive if I want to. And your lordships have held, the Honorable Supreme Court has held many a time, fundamental rights cannot be waived. And there cannot be latches, on my part. That's why, Millards, that plea I don't think is available to them. Then, Millards, if at all they have said that in the four corners of the recruitment policy, they have done their job, Millards, my humble submission is, Millards, beginning from 1854, to this day, my lords have repeated, from Taylor versus Taylor to Nazir Ahmad, to this day, Millards, once a statute mandates things to be done in a particular way, either they should be done in that way or not at all. And that's been the established principle, Millards. Here, very curiously, my lords could see, Millards, examinations were held. First prelims were declared, then main exams were held, then avalanche of allegations started coming forth. In that sense, Millards, as a matter of knee-jerk reaction, post factum, they've started issuing press notifications, clarifications, etc. And in all those cases, millets, it's something like as MS Gill could echo for that principle, millets. They could not justify their conduct post factum with all, rather they're trying with hindsight and wisdom dawning upon them late that it could have been this way or that way, and that's how we have done. This plea, in my humble submission, is not available to them. This is what I would like to submit, millets, in elaboration. Millets, also, when it comes to the state or its instrumentality, in the words of Honorable Justice Bhagavati Millets, as the Lordship then was, must be held to the standards by which it professes. And my lords could see the material they have supplied. Everywhere they have said that fairness, transparency, all these things we swear by. That's why we have adopted the method. And unfortunately, millets, except fairness, except openness, they have done everything else, it seems, millets. Then millets, and the other one is, it's just another recruitment. I wonder, millets, in my humble submission, is it so? When it comes to state civil services, my lords could see, millets, a class 4 employee with a simple notice could be removed or with some due procedure. At the higher echelons, it can still be treated as a simple job and that could be removed. There are constitutional protections as the responsibility rises, as the position grows up. In this case, millets, for any aspiring young student, millets, it's a lifetime opportunity to be a civil servant. Usually, millets, they get trained and prepare for civil services, UPSC, millets, Union Public Service Commission. Then, millets, they also go for this one, if not there, here. Because down the line, they could have the conferment. And millets, life and career, they can't be separated. And they cannot. Perhaps for a lawyer, a case may be a number, not for the client. Not for these people who have been waiting for decades. My lords may kindly appreciate, when it comes to UPSC, it's an annual affair. And you will have 3 opportunities, and you could as well try and indicate your stand, but not here. They come once in a blue moon, and most of the times they get stymied. And here, millets, this is the 3rd attempt. Earlier it was a failure. Second time it was a failure. Millets, what the Public Service Commission could be telling your lordships is that we blunder on by way of trial and error. If somebody catches hold of us, it is for them to prove that we erred. I'm afraid, millets, it can't be. They are an instrumentality of state having the responsibility of conducting the examination for the highest recruitment of the state in the manner as they professed. Once they have done it and caught napping, they would not be supplying all the latches, millets. This is my broad parameter of my submission, millets. And millets, may I take your lordships to the notes that I have given, millets. My lords permit, millets, I run through that one. Wherever it's been clear, millets, my lords may kindly just ask me to just move on so that I could finish it up.
In fact, the headings that you have already coined, if you can just one after the other go through the headings, because these headings would clearly indicate as to what has already been argued on those points. The preparation in your written submission coins it down to more specific paragraphs, maybe where the findings are
Indeed,
there.
millets, in every case,
So
I have
that
given
would-
the paragraph numbers as well, the page number, and the contention of either party, and the conclusion of the Honorable Learned Single Judge as well. I have given, millets. So that, millets, a voluminous judgment, and wading through that even for your lordships, millets, down the line with all these arguments, it's an arduous task, millets. For that purpose, I thought that I could as well have some signposts placed in my submissions so that they could lead to the points where they've been dealt with.
So if you can touch the broader head points, that itself would give us the
So be it.
cue, because we have dealt with it in quite detail during the course of this last.
Yes, millets.
fact,
I could as well anticipate that one, millets. And millets, if at all my lords feel on any aspect that some light to be thrown and that's not been dealt with
We'll put a
earlier, so that I could be warned on that aspect, millets, I'll just elaborate on that.
Right.
Millets, my lords could see, millets, when it comes to which is the first one that begins. Well, let's kindly come to page 279. Only this page I refer, otherwise I'll be reading. Rather, just taking out the headlines on the headings rather. 279 minutes
Yes.
is the lead writ appeal I have based my submissions on.
The moment I opened the 279 itself came, because we have
Oh.
opened it so many times.
That's come straight away, millets.
Straight away.
Millets, there is a beautiful word which India contributed for that one, millets. Serendipity. Sarangadweep is the word that has gone into English language as serendipity. Something coming to us when we are about to search.
True. So,
My lords could see that, millets. Here, the learned single judge has divided the flaws on the part of the recruitment agency, the Public Service Commission, into two aspects, millets. One is procedural aspects, issuing of 2 hall tickets for the Group 1 examination, allocation of examination centers in a biased manner, inconsistency about the total number of candidates who appeared for the main examination, multiple evaluation of answer scripts, publication of provisional total marks list, disclosing of unqualified candidates' hall ticket numbers in the main final marks list, increasing vacancies by adding new vacancies, then method of evaluation, millets, the selection of the evaluators, the procedure of evaluation, Telugu medium candidates were neglected, highest qualified candidates in specific centers, commission awarded the same marks to certain candidates. These have been elaborated by the learned single judge, millets. My lords may kindly come to the notes now, so that I will not trouble your lordships. Millets, at page number 279, I've already mentioned, paras 303 to 310, they deal with the aspect of dual hall tickets. And millets, there it's been held that that system could not have been adopted. And millets, kindly see there is one word at para 307, page number 281.
yes.
I think some argument has been advanced by the appellants on this aspect. Let's kindly come to 307. Para 307, that's page number 281. Could be volume 1. 281.
Yes.
Minutes 281, para 307. After reviewing the Commission's explanation that regarding its administrative feasibility, they adopted the said procedure. For this type of direct recruitment, the Commission has to follow the Telangana State Public Service Commission's rules of procedure. In the said rules, nothing was stated regarding the issuance of 2 hall tickets. Further, the procedure followed by the higher commission, such as the UPSC, generally the State Commission ought to have followed the same system. The Commission erroneously issued 2 hall tickets to the candidates. The unsuccessful candidates questioned the Commission's action in issuing 2 hall tickets. And Millet's next paragraph, it says the Commission did not provide clarification, etc. Here, Millet's, it seems, some emphasis has been laid on higher commission and state in a federal setup having its own recruitment agency for the post, for their own post, Millet's. The question of there being copycats to the other one will not arise just because they have not followed the procedure which is being followed by the UPSC. May not amount to any violation, was the argument addressed. And Millet's, the expression higher commission. Millet's, what could have been weighing with the honorable judge is this, Millet's. Kindly look at the professional level of conducting civil services at the all India level. And Millet's, and it's an annual affair encompassing all languages, all states, with enormous scope for mischief, but never heard of. So in a sense, Millet's, they have perfected the system of recruitment, and we need not reinvent the wheel when it's already been there. That could be made use of. That could have been the intention of the learned single judge. When it's been said, there is a set procedure. And that has never given rise to any eyebrows getting raised. In that sense, Millets, you should have followed that one. That's the way that's been expressed. It doesn't mean, Millets, that they're not following amounts to denigration of any of their rights. And in fact, Millets, in the judgment, it's been demonstrated how this system has given to confusion, how the candidates, even they are not certain about the number of candidates that have appeared for the mains examination. At every place, they are given every number that's been tabulated, even in my notes also, Millets. Then, Millets, in fact, for the ease of reference for my Lord's Millets, I've also extracted what's been relevant in those things. Now, let me go to the conclusion, Millets. That's para 310. In my notes, Millets, the conclusion part, my lords could see, para 310 at page 382, I said, in these circumstances, this court is of the opinion that the entire exercise, beginning with the issuance of 2 hall tickets, was not as per the notification or rules. The commission's action creates doubts about the conduct of the examination. Now I'll go to the second issue that's been raised and considered by His Lordship Millets. That is 2, center allocation. Paras 311 to 318 deal with that one, Millets. Para 312, that is the commission's process they have explained to the court. Then, Millets, at para 313 rather, letter dated 15/4/25, that's a press rejoinder.
Yes.
One moment, Millets. Where is this press rejoinder? Oh. Yes. No, which is the page number of the press rejoinder? Could you give me that? My lords, here at para 314, the court put a query. The commission stated that while allocating the examination centers in a fair manner, they applied a rationalization method. If the commission had followed the same approach, then how were the centers 18 and 19 given priority only to female candidates? Then, Millets, at para 314, page 286, the commission mentioned in particular center numbers 18 and 19. The college authorities themselves requested the commission to allot only female candidates to their college. The commission, to that extent, they mentioned in the pleadings, but did not provide any documentary evidence. Para 315 at page 286, there's no proper answer from the commission. Moreover, they stated that the commission prioritized female candidates to protect their freedom. If both genders were allotted the same college, security issues might arise. Though there is no rule in the commission's rules of procedure or in the notification to give priority to the female candidates, the commission's action amount to a violation of their own rules of procedure and notification. Finally, Millets, it's been held in para 316, continuing. On the one hand, the commission claims that it has considered social justice, logistics, and amenities for all candidates in the allocation of centers. On the other, it has not followed the same. The said action of the commission amounts to a violation of the principles of natural justice. Then, Millets, 317, it elaborates. Finally, 318 para, it concludes. If the randomization method was used, that's been very elaborately discussed before your lordships by other learned senior counsel Millets. If the randomization method was used for the allocation of centers, then how was majority of female candidates allotted to only 2 centers? It deviates from the meaning of the randomization. The purpose of this method is to minimize the selection bias, but whereas the commission is acting against it. Then, Millets, my lords, may kindly come to the third issue that's been raised and considered. Candidate numbers discrepancy. Paras 319 and 20 deal with that one, Millets. And my lords could see at 319, it begins, Millets, the caption, inconsistency about the total number of candidates who appeared for the mains examination, page number 287. And Millets, all the numbers apart. My lords may kindly now turn to page 320, rather para 320. I may read this sentence, Millets. 320. The commission, after 5 months, suddenly released a final marks list dated 30th March 2025 with 21,085 candidates having written the mains, and absolutely no explanation about the sudden increase in numbers. Then, Millets, my lords may kindly see. Right? We'll come to that one. Fourth point, minutes. Multiple evaluations. The third evaluation defect, paras 321, 322, they deal with that 1 minutes. 321, the commission's method has been explained, and minutes at para 322, the court's finding. My lords could see 322 minutes.
Yes.
May I just read this minutes? However, the fact remains, para 322 at page number 289. However, the fact remains that the APPSC evaluated the mains answer scripts just like the TGPSC. Nevertheless, the evaluation conducted by the APPSC, all the three evaluations followed the same method using barcode and bubbling. The third evaluation conducted by the commission differs. Due to this lapse, there is every chance of manipulating the marks in the third evaluation. The acts of the commission reflect that they did not follow any recognized and proper evaluation method, and moreover, the commission issued a press note on 13/3/2025 indicating the point number 3 that double valuations of all answer scripts is mandatory. However, in the said notification, they did not explain or provide any details regarding the third evaluation. It seems that the commission totally violated the notification and rules of procedure. To substantiate their deviation, the commission in their common additional counter affidavit filed on 25/6/25 submitted that provisions have been made on the first page itself for the two evaluations. However, the third evaluation, which is necessary only in a few cases, is provided for on the third page of the answer booklet. The sample answer booklets were published on 16/8/24. My lords may kindly appreciate one thing here, but when it comes to the notification, it was totally silent about the method of evaluation. When an issue arose after the examination, they issued a press note rather. In that one, they have said that, millets, no, we have got a double evaluation. But they have not spoken about any third evaluation. Then, millets, when the issue came before the Honorable Court, for the first time in their additional counter, they say, no, we have also had a third evaluation. To just link all of them, they say, look, we have provided a model. In that one, there is evaluation 1, evaluation 2. In the next page, there is another one which has not been numbered as evaluation, but that should be taken as third evaluation. I mean, in my humble submission, it's an afterthought. Had there been any such procedure, that could have been reflected in the notification or at least in the press note. Only when the matter came before the court, we raised the plea to that effect, then they give this answer. And millets, to satisfy the judicial conscience of your lordships, millets, perhaps nothing stops them from placing before your lordships in which manner the first one has happened, the second one has happened, in how many cases they've had this third evaluation, how the marks are varied. That has not been forthcoming, millets. There is a stony silence in my humble submission. Then, millets, I'll go to the next point, millets. Non-publication of provisions mark list, fifth one, millets, if I read that one. I read multiple evaluations I have read. Right. May I move on, millets? The fifth one.
Yes.
Non-publication of provisional marks list, paras 323 to 330. Para 323, page 291. The notification clauses have been stated. Thereafter, millets, 324, the court's finding. 324, millet, the commission, as per the above rules, ought to have published the total marks of all the candidates along with provisional subject-wise marks. Without doing so, the commission sent individual subject-wise marks to the individual logins, which is incorrect, arbitrary, and violative of their own rules and regulations. 325, the commission, without accepting their mistake, tried their level best to cover the said mistake and stated as follows. Paragraph 15.3 did not mandate publishing once consolidated list of all candidates reflecting total provisional marks obtained by them. It only mentioned publishing a provisional marks list, which published on the respective account of each candidate, and also not only that, the final list reflecting total marks of each candidate after the completion of the process of recounting was published, etc. Minutes. I'll not trouble your lordships. I'll come to the finding part, page 320, rather para 326 minutes. The petitioners object that the commission violated their own notification, completely flouting clauses 15.2 and 15.3, thereby forcing a deliberate secrecy between the initial provisional marks that was deliberately not uploaded generally, but only sent to candidates, logins individually, and the final GRL released on 30th March 2025, giving room to the commission a lot of mischief and several situations where marks could be randomly changed. Now, my lords may kindly see minutes. 327. In this regard, in the vacate stay petition, the commission did not disclose whether they have followed clause 15.2 and 15.3 or the notification or not. The conclusion, my lords, 330 para number. May I read? Yes. It's incorrect to suggest that the commission failed to follow its own rules, and it cannot be caused. Candidates who have been appeared for the examination have every right to question whether the commission has followed its own prescribed rules, regardless of whether the sentence may not have been happily voted. It's been said, millets, we're not stopped and we have got every right to question that one. That's how it's been suggested, millets. Then the sixth point, millets. Disqualified candidates have been evaluated. Millets, what's been said here, English is of generic nature, it's only qualifying, its marks will not be taken into account. If they fail to have that qualifying mark, millets, then means rest of the papers could not be corrected. Here, they've been corrected. And the rule is very clear, loud and clear rather, that cannot be. And the answer that's been given, it seems, millets, by the appellants in the arguments before your lordships is this. Well, sometimes they may go for re-evaluation or recounting. In that case, then if somebody passes, then their evaluation has to take place. To avoid that eventuality, we have added them also in the general list, and we have corrected all these papers also. I'm afraid, millets, in anticipation of some contingency, they can't break the rule. That's what they have done, millets. That's been said at para 331. My lords could see, millets. 331, the commission filed an additional counter where they have explained this thing, millets. Then my lords could see 332, the purport of rule 12D of the notification is as in para 332 or 295. The paper of general English is a qualifying one. The minimum qualifying marks in this paper are for the candidates belonging to OCs, sports, sportsmen, and EWS should not be less than 40%. That is 60 marks. BCs not less than 35%. That is 52.5 marks. SC so and so, not less than 30%, etc. 333 minutes. If the commission had followed the above method in evaluating, page number 295 minutes. And my notes mentioned that para 332 at 295.
Yes.
In fact, millets, though there is no tabulation there, I have tabulated which way the marks have varied. My lords could see in my notes, millets, under point 6, that there is a table I have extracted from para 333, showing the discrepancy and the disparity when it comes to the candidates who have not qualified in English, but still they have gone ahead. Millets, my lords may kindly have a look at my note, millets, where I have also stated about para 334. The above table indicates that candidates who are disqualified in the qualifying exam, general English, but their other papers were also evaluated and total marks were published, which contradicts their own rules. This itself demonstrates how the transparency maintained by the commission in evaluation of the answer scripts. 335 minutes, salutary. The commission, being a constitutional body, in the process of Group 1 mains exams, deviated from the mandatory rules, which is unacceptable. And it shows that there is no transparency, fairness, and integrity in conducting the examination. It appears that the Commission violated the principles of natural justice, which is unconstitutional. The acts of the Commission are reflective that it causes injustice to the unemployed youth who have a strong hope. Vacation minutes, I can stay back and argue tomorrow if my lords permit.
We'll continue tomorrow, but who else on behalf of the writ petitioner? Oh, Mrs. Reddy, you are there.
I'm there.
We have one more connected matter in the same.
So you are the only one left to argue?
I believe another senior also is appearing.
Case Murthy also, the senior counsel.
I mean, we won't reiterate our request because
I'll take only 30 minutes, flat minutes tomorrow.
because all of you understand that issues and facts have already been placed a number of times. So it would be nice if it is restricted as far as possible.
I believe minutes, it could be concluded tomorrow, of course, subject to their reply.
Replies won't take much time, hopefully.
Learned AG leads me. I think if they finish by lunch, we'll finish by the end of the day.
Oh, we expect them now to complete, say, in half an hour or at the most 1 hour, and thereafter 1 hour to the state to reply. So by lunchtime, we should be over by
Yes,
this.
So they can conclude by 12:15, 12:30. We'll conclude by lunch.
That's the idea.
Millets.
Ms. Reddy?
I mean, lunch would be typical here also, because if I take
No, but the points that are being made, you have been attending the proceedings. In fact, throughout, you know that
yes, Your Lordship. Other than the points that have been made itself, I believe I need at least an hour and a half. And I don't know about the other senior. So I believe tomorrow and day after.
an hour and a
Me,
half.
30 minutes, please.
Mr. Murthy usually is very short and sweet. So half an hour, 1.5 hours. Mr. Murthy might take 15 minutes. From my past experience, here before the learned single judge, he was the most crisp, apart from being the most impactful.
So the other senior would also take a cue and make it that short.
We will try, Your Lordship.
So please try, because it ultimately it may satisfy your effort, but it may not be required if you repeat the same.
Other than the aspects that Your Lordship was putting.
Because we have to wind up the matter also so as to do our own preparations thereafter.
Yes, ma'am. It takes a lot of time.
Lordship, the holidays start from day after, so tomorrow and day after, I guess it is.
No, in any case, we are going to finish it off.
Yes.
Tomorrow by lunchtime or maybe half an hour after lunch. Otherwise, we will rebel. So you'll have to, these are the written submissions. Don't mix them with the files. These and our notes. Very well. Take down the appearances, arguments, continue tomorrow.